joining us. I'm Deepinder Mayell. I'm the Executive Director of the ACLU of Minnesota. And we're here today to discuss the Supreme Court's ruling in the Schroeder voting rights case. With me are three attorneys who are instrumental in this case, two of our clients who are deeply affected by this ruling, and Brian Fullman, who is helping lead the Restore the Vote Minnesota Coalition. You'll see a few people had to join us via Zoom and others that are in person. This is a bad day for democracy. This is a bad day for Minnesota. When we filed this lawsuit in 2019 to restore voting rights to thousands of Minnesotans, we did that because we believe that voting is a fundamental right, that the right to vote is essential to any democracy. It is essential to our democracy. It is essential that people who are living in the community, working and raising families, have a voice and a vote in their own futures. And that is what is at stake here, the promise of our democracy. Since the country's founding, people have been fighting to ensure the right to vote extends to all, and that obstacles from poll tests and voter ID are removed. Much of our country's history is about this critical fight. The ACLU has been in this fight for over 100 years, and here in Minnesota for 70. We have fought in the courts, we have fought in the streets, and at legislatures for the right to vote to extend to all. The Supreme Court disagreed with that in its ruling today, but we take heart in their recognition that the legislature has the power to change that. There is an opportunity to do what is right. The Minnesota legislature must protect the right to vote for all, and we'll do everything in our power to urge the Senate to join the House in passing this bill. Now, this is a long journey. We know that, and this is an opportunity to take a historic step in that vital story. Next up, I'd like to introduce David McKinney, staff attorney of the ACLU, who's on Zoom.
Well, thank you, Deepinder. Scripture tells us, let us not grow weary in doing well, for in the proper time we'll reap a harvest if we don't give up. Reminded of that today. Thanks everyone for being here. I'm so sorry that I was not able to be there in person with you all, and I'm disappointed by the court's decision. I'm disappointed because the real world consequences of the court's decision today is to leave in place a disenfranchisement scheme that impacts more than 50,000 Minnesotans disproportionately of color. I agree with the dissent when they wrote that in closing its eyes to the clear racial disparities emanating from the statute, this court demeans our Constitution's promise of equal protection. And to be clear, the racial disparities are stark, lest we forget, Black people comprise about 6% of Minnesota's voting age population, but 24% of these disenfranchised voters. Native people, about 1.5% of the voting age population, and 7.5% of the disenfranchised. And Latinx people, about 3% of the voting age population, but 6% of the disenfranchised. And a majority of the court today acknowledged these disparities. And they even went so far as to describe them as a deeply disturbing reality in Minnesota. However, they refused to act. Only the dissent went so far as to recognize this court's unique role and awesome responsibility to act on these disparities. The dissent made clear that the statute acts as a gatekeeper to the franchise, determining who will have a voice in the democratic process and who will continue to be relegated to political marginalization. The dissent made clear that the racial disparities generated from Article 7's felony disenfranchisement provisions are unacceptable, and they sanctioned discrimination that are particularly perverse in voting rights contexts. Because in doing so, it inhibits the ability of politically powerless to redress discrimination through ordinary political means, further marginalizing those who seek to re-enter society. So I'm disappointed. I'm disappointed today in the court's decision and in their inability to take seriously the racial injustice that this law perpetuates, particularly in Minnesota. We can do better than this, and it's now up to the Senate to do better. In citing Justice Walz's observation in Russell, the dissent reminds us all, there comes a time when we cannot and must not close our eyes when presented with the evidence that the laws are unjust, regardless of the purpose for which they are enacted, and which discriminate unfairly on the basis of race. That time is now, and it's up to the Senate to protect democracy, to ensure that these discriminatory laws are abolished, and that every Minnesotan living in the community can vote regardless of whether they've had a felony conviction. I do want to take a moment. This may be our last moment, and many of you probably know that this lawsuit has been going on for several years. So I want to take a moment to recognize the great support, overwhelming support we received from numerous government entities, nonprofit organizations, legal clinics, and other groups who filed friend of the court briefs urging the court to rule in our favor. Thank you for your support. Many did so, and many did so with pro bono counsel in tow. And let me also give a special thanks to our pro bono partner, Faegre, and particularly Faegre Drinkers partner, Craig Coleman. Craig worked tirelessly for the last several years on this case. Many weekends, many late nights. This case took him, I'm certain, from friends and family time, and he did it all because Craig deeply believes in voting rights and racial justice and ensuring the democracy, the efficacy of democracy, and in working for social change for the betterment of Minnesota. And he did a fabulous job arguing before the Minnesota Supreme Court, articulated our positions, and I really do. We owe him a very big debt of gratitude. So thank Craig very much. And with that, I'll actually turn it over to you, Craig. Thanks so much.
Thanks, David. I'd like to underscore one really important point from the decision and the litigation generally, and that is that no one, not the framers of the Minnesota Constitution, not the court in its decision, or any of the lower courts, not the legislature, not the parties, no one has ever articulated any sound reason to disenfranchise persons who live and work in our communities on supervised release. And it's corrosive to our democracy. It's counterproductive to the aims of our criminal justice system to deny citizens in our communities who are living in our communities, raising families, participating in citizenship in every other way, to deny those persons the basic right to cast a ballot and to participate in our elections. Nothing in the court's decision denies that fact. And so with the decision today, the disenfranchisement of tens of thousands of citizens living and working in our communities remains a terrible injustice that still has to be redressed. We brought this lawsuit after many years of legislative failures to correct that problem. And it's critical that the basic message from the court today in the decision is that the legislature has the discretion and ultimately the responsibility to fix the problem. Our clients now have no recourse to the courts, and it is therefore past time for the legislature to act. Now, this decision would be truly devastating to our clients and to all Minnesotans who are disenfranchised while living in the community if we did not have some hope in the form of the bill that is currently before the Senate. We believe that the court should have fixed the state's flawed system of disenfranchisement. But ultimately, the history of our democracy shows that every branch of government has a role to play in protecting the right to vote, protecting democracy and democratic participation. So the current bill that awaits a vote by the Senate is an essential opportunity to restore voting rights to the tens of thousands of Minnesotans who are deprived of the right to vote for no good reason. And we urge the Minnesota legislature and the Senate to finish the job and really relying on you and Governor Walz to end this injustice. Thank you. National ACLU played a really essential role in the litigation and supporting it. This has been a mission of the Voting Rights Project at the ACLU, fixing the flawed system of felony disenfranchisement throughout the country. We have Julie Ebenstein from National ACLU to talk next.
Good afternoon, everybody. I'm Julie Ebenstein. I'm from the ACLU Voting Rights Project. The Voting Rights Project is committed to challenging felony disenfranchisement and promoting restoration in states across the country, both through the courts and in promoting participation with the communities that are affected by disenfranchisement laws. Extending second chances to people with a prior conviction, folks that we like to call returning citizens, serves rehabilitation of those individuals. It serves public safety for the extended communities affected, and it promotes democracy. There has been a growing trend, particularly in the last 4 years, towards either disenfranchising fewer people or restoring their rights more quickly. There are at least 7 states that have restored rights to individuals upon release from incarceration. In the last 4 years, they have changed their laws to bring back people's voting rights as soon as they rejoin their community. And there has been a general trend away from lifetime disenfranchisement. The 4 remaining states that impose lifetime disenfranchisement no longer do, whether that's through legislation, executive order, or citizen initiative to amend the Constitution. In effect, as you all saw from looking at the facts of our clients' cases, disenfranchising people for decades at a time essentially imposes lifetime disenfranchisement. It excludes people from the electorate for the rest of their life and never lets them return to full citizenship. We hope that the legislator will act now to restore rights, at least upon release from incarceration. And we know that the people of Minnesota will continue to work to restore rights to our fellow citizens once they are released. Thank you.
Next up, we have a plaintiff in the case, Jennifer Schroeder.
Hi, I'm Jennifer Schroeder. I'm standing in front of you today, and I am angry at this decision. I'm angry because the disparities and disenfranchisement will continue. I was the lead plaintiff on the ACL's lawsuit because I believe I should have the right to vote. I believe that Minnesotans who have been released from custody should have the right to vote. They should have the same rights as their neighbors, rights that are preserved in our state's constitution. For the first time, I had hope that our judicial system would make the right choice in this case. I had hope that 53,000 disenfranchised Minnesotans would be granted their constitutional right to vote. And I am truly disappointed in this decision. I'm disappointed that we are being denied this fundamental right. I have my degree in addiction counseling. I am now a stay-at-home mom. I closely worked with the legislator to make changes in law, but that's not good enough. But today's ruling by the Minnesota Supreme Court means that I can't vote till I am 71 years old. The court decided that I am not worthy to be a full citizen of this and a full member of this society because of a past drug possession charge. By ruling against our case, the Minnesota Supreme Court has said that what I am doing and who I am is not enough. I am not good enough. The ruling means that I am unable to hold elected leaders accountable to help build a better world for my son. When my son is old enough to go to school, I will not be able to vote for the board members that will make decisions about his education, or the lawmakers who will make decisions about my family. I urge the Minnesota legislature to restore my right to vote. If you don't act, my son will never see me cast a ballot. I stand here representing all of the people without a voice. All of the people who are on probation and have been labeled felons, the people who are homeless and struggle with addiction, the people who do not have a voice and have been disenfranchised from this society. I stand here as a voice for those people who have been marginalized, and I am urging the Senate to restore the right to vote to these people. Voting is a civil right. It should be our right too. The voices of the people who are struggling should be heard, not silenced. We cannot continue to be silenced. Thank you.
Thank you, Jennifer. And now we're going to go to Zoom with another plaintiff in the case, Elizer Darris.
Thank you so much. My name is Elizer Darris. I am co-executive director of the Minnesota Freedom Fund. I'm also one of the plaintiffs on this case. First and foremost, I want to thank all of the attorneys who have put in significant work over a very long period of time to fight for justice, quite frankly. This is a dark day and yet another stain on democracy in this nation. For the High Court to acknowledge that there are troubling racial disparities in the numbers and in the execution of the current law, and yet take no steps to end the racist state policies beyond expressing what to me is essentially thoughts and prayers is exceedingly disheartening. You can't tell me that you see how bad it is and say that you hope that the legislature take actions to alleviate the stark racial disparities, particularly for African Americans in the state of Minnesota, where we find many different indicators of the quality of life in Minnesota to be very stark for African Americans in this state. And this disparity is yet another example of that. And so it's very disheartening that the High Court had the power to move on this and to end this particular representation of disparity and chose to instead not take that action. That is disheartening. It's largely disheartening because I believe in the power of law to create the realities and the life that we want. I believe in the power of the ballot to create the life that we want. I fundamentally believe in the power of the ballot. This is why I find myself canvassing in 90-degree weather, trying to help other people utilize the power of their voice to make it to the ballot. I will canvass in 15-degree weather. I will canvass 100 doors. I will canvass 1,000 doors, and I will fight to convince people to allow their voices to be heard, because I fundamentally believe in the power of the ballot, and yet to be denied once again by the High Court. It's beyond disheartening. I'll tell you what I will not do. I will not abate back into the darkness. I will not go out and canvass doors. I will not give up on democracy. I will not give up on trying to convince people to use the power of their voice to access the ballot. I'm not going to go back into the recesses of darkness. That's not going to happen. We're going to continue to fight. I'm going to hope that the Senate joins the State House in passing the legislation off of its floor so that the governor can then move to change what the High Court has acknowledged is a pernicious problem in this state. The disparities that are produced with this state-sanctioned policy is outrageous. And so I'm going to hope that the state Senate utilizes its power to change this and to end this. And that is the expectation. But I'm not going back into the darkness. I'm not going to fade away. We are not going to fade away. We're still your neighbors. We're still going to be your painters, your carpenters, your teachers. We're still here. We're still in society. The only difference is the High Court has just ruled that they don't believe they have the power to end this state-sanctioned racial disparity within the state. We're going to continue to fight. We will access the ballot.
Thank you, Elizer. And finally, we have Brian Fullman, lead organizer of Restore the Vote Minnesota, and our partners Isaiah and Faith in Minnesota.
Thank you. So you all just heard everybody. And what I want to do is piggyback off what Elizer Darris just said. We won't stop. We are intentional about building the community power that is necessary to leverage and show a public mandate to restore the vote for our brothers and sisters who are now currently disenfranchised, not able to use their voices at all. It hurts. I admit it hurts that the High Court of the state of Minnesota did make drastic measures and changes to ensure that we all can use our voices. But we've been organizing the whole time. We haven't stopped organizing, you all. We've been on the grounds, knocking doors, canvassing, strategizing to actually show the state of Minnesota that people do care, that there's a bill in place to make sure we all have a voice. This bill passed through the House with bipartisan support, you all. And this bill will pass through Senate. We don't know when the Senate floor vote is going to happen, but our organizing doesn't stop. And I just want to be clear that we always knew that the legislature had the power to create this change. So yes, I'm not comfortable with the outcome, but as an organizer and being true to what I do, it actually opens up the opportunity for our everyday brothers and sisters to co-govern with our legislators and make sure that Restore the Vote passes. And I'm very confident that this will happen. So when we get that date, I hope you all get that date, and I hope to see you all there. Because the rally is going to be full of energy. It's going to be full of people who normally not asked to use their voices. And we're going to have their constituents there to make sure that the legislators understand that we're partnering with them. We're encouraging them to continue to lead in a very bold way. And we'll be there to celebrate them when they come out of those chambers. Thank you.
That's all for the speakers. Are any questions?
Can you talk about, the bill in the Senate is pretty much, I shouldn't say is a done deal, but Democrats in control have said they're committed to passing this law. Can you talk about how, if the legislature acts on this matter, why you still wish the court had ruled to give that other layer, if that makes sense?
Yeah,
Why it matters as much if the legislature will act on this as the court described in its opinion too.
Yeah, it goes back to the point that I made that it really takes a commitment of every branch of our government to protect the right to vote. One decision, one amendment, one state clause in a constitution is not enough to secure our democracy. Democracy is an ongoing commitment. It's a culture, it's a value, and we need every branch of government. We need all of our legislators. We need the courts to protect the right to vote. And so if we had prevailed today, and if the court had overturned the system of felony disenfranchisement, we would still be calling on the legislature to do the right thing and underscore its commitment to the right to vote. The fact that the courts, which we expect to be the place where the disenfranchised should go for relief, has unfortunately turned their back on our clients and the disenfranchisement. It makes the legislature's job critical to fixing this injustice.
I don't think that we knew that it was going to be this in
Come on up to the
House.
microphone.
Oh, sorry.
Yeah, thank
I don't
you.
think that we really necessarily knew that it would be at the House and the Senate right at this moment either. It seems very politically charged that the decision came out at this time. But I think that we were expecting the ruling to come in a lot sooner than 15 months. We've been waiting for this ruling, and it sent a message that that the disparities are going to continue, and we just happen to have the House and the Senate ruling at the same time as this. So I just think that that's important to say too, that this was a whole separate thing.
And I'll just add, I just think that the court was wrong, right? I think that, the Minnesota Constitution protects rights. And I think it protects these rights, and protects when there are harms to your constitutional rights. And I think Minnesotans believe that our Constitution protects these rights as well. So it's really important that that interpretation is correct.
And I guess, yeah, and that's exactly what I wanted to follow up with, is that even though you're likely to get the same outcome from the legislature, you were hoping to get this support from the courts. Is that it? If the court had ruled in your favor, is that a stronger legal statement than if the legislature changes the law? I don't know who wants to address that.
I think it's let me just chime in here. I mean, I think in terms of whether it's a stronger legal statement, it certainly is a statement about what the courts view their role in the process as. And the dissent in this case wrote a powerful statement around whether the court views itself as a protector and arbiter of constitutional rights, whether the court views itself and takes seriously equal protection, and how it applies to all Minnesotans, regardless of their color or race. And so I think in terms of what the message would have been sent, what message the legislature and what the people of Minnesota would have gotten from a court decision that would have ruled against disenfranchisement and striking down this statute, would have been a statement about what the values of the rule of law and of the court's role in viewing its strong protections for all Minnesotans in their voting rights.
Anybody else have any questions?
Yeah, would somebody be able to speak just the length of, or how long it took for this decision to come? I mean, that's not really typical, is it? I mean, in some maybe similar cases, I mean, it wouldn't take 15 months, right?
So the Minnesota Supreme Court cases can take quite a while. This is long, even by the standards of Minnesota Supreme Court decisions. But the case was presented difficult issues. There were 3 decisions, so there was a majority decision, a concurrence, and a dissent. And we recognize that takes a while to work through. So, we take it that and acknowledge that the Minnesota Supreme Court worked through the issues in good faith and wrestled with difficult issues. And so I think at the end of the day, the fact that there's the timing of the decision may coincide with the legislation and the Senate's decision will take to be a coincidence. And ultimately, we hope that it eases the pain and the frustration of the decision. Certainly, if the Minnesota Senate does the right thing, passes the bill, at the end of the day, our clients will be able to vote, and that's what matters most.
Just to be clear, the constitutional questions that you argued in this case were that these restrictions under state law violate the Constitution on the Equal Protection Clause and also the fundamental right to vote. Was there another constitutional question there, or challenge, I should say?
No, that was it. It was the right to vote is a long been acknowledged to be a fundamental right under the Minnesota Constitution and by the Minnesota courts. And we believe that the system of disenfranchising persons living in the community violates that right. As David explained, there's also a problem of just the extreme racial inequities in the criminal justice system, which leads to serious racial disparities with respect to persons who are disenfranchised. And we think when it comes to racial inequities with respect to the right to vote, that should set off all of the most serious alarm bells for the courts under our Constitution. And we urge the court to act on that basis.
Anything else, anybody?
Thank you.
Thank you. You all have my cell number if you have any questions in my email, and if you have any questions, please do call. I just wanted to note that in the haste of doing this quickly, we want to make sure that that Craig Coleman is with Faegre Drinker. There were a couple of changes in firms since the very original case, so it's been a while and we're coming. Thank you. And thanks for your patience with our having folks on site now.
I can definitely see my cell phone.
Okay.
Thank you.
Thanks so much.